Hi guys, welcome back to Diary of Law. So I hope that I'm a subscriber and like welcome to this Diary of Law. Today we're taking our deep dive into law of torts. Specifically, we'll talk about liability for animals. So liability for animals is strict liability, and so this means that the owner of the animal is strictly liable. He's liable regardless of fault or negligence, whether it's an accident or not. He'll be liable for whatever his dog or his animal does. That is what strict liability means, especially when it relates to liability for animals. Liability for animals is divided into two. So we have cattle trespass, and then we have the scientific action, which is liability for dangerous animals. So they're going to look specifically at liability for dangerous animals, and then perhaps in other classes we'll discuss like cattle liability. When it relates to animals, we have two types of animals. So we have animals feral, natural, which are naturally vicious animals that are naturally dangerous. And then we have animals mansuet, natural, regularly domesticated animals in that sense. So like dogs, cats, those are animals mansuet, natural. So animals that are naturally dangerous like tigers, lions, gorillas, elephants, their natural behavior is to be dangerous, is to be ferocious. However, they can be domesticated, but where their natural instinct is to be wild, to be dangerous, to be harmful to other people, they fall under the category of animals very natural. Animals mansuet natural animals that are naturally domestic, naturally harmless. So naturally, a regular dog, like a normal dog, is supposed to be harmless, supposed to be friendly, supposed to be playful. Right, cats, supposed to be animals that are naturally harmless, and so they fall under the category of animals mansuet natural. Do you understand? So for any animal within the category of animals that are naturally harmful, animals that are naturally ferocious in nature, any animal under that category, any of them at all, the owner or the keeper of that animal will be strictly liable whatever the animal does, because it has that propensity, that capability, that natural inclination to be dangerous, to be harmful. So in the case of Berrant versus Bertram Mill circus, in this case, a tame animal, a tame elephant, right? He injured the plaintiff, and the court held that even though the animal was tame, it was an elephant. And elephants have a natural propensity to be dangerous based on their demeaning, disposition, their physique, so they had that propensity, and as a result, even though the owner of the elephant claimed that it was tamed, was domesticated, he was still strictly liable for the injury that the elephant caused to the plaintiff. However, when it relates to animals that are naturally domestic, animals that are naturally friendly, naturally playful, like dogs, cats, things like that, the only way that the owner will be liable is if one, the animal had displayed perhaps in the past a propensity to be dangerous. For instance, that rat that you're keeping in your house, that dog that is in your house, that dog has beaten your neighbor's daughter's uncle's son. That dog has stolen meat from your pots. That dog has done so many weird things, right? That dog had shown in the past a propensity, a likelihood to be dangerous. If your dog that has that attribute then goes ahead to kill somebody's child, you're liable. You cannot say that, you cannot feign that, because it's a domestic animal, because it's an animal that the category of mansuet natural, then you let it would slide in the court. So it will not, because that animal has displayed a propensity, a likelihood to be vicious. So the second requirement is that the owner knew. So there must be a knowing, there must be knowledge. If, for instance, the owner was not aware that animal had such a vicious tendency, then he may be able to escape liability. But if by any chance he was even in the slightest method or way aware that that animal had such a tendency, then he will be strictly liable. Even though it's a domestic animal, even though it's a playful, generally accepted to be harmless, it will still be liable if one, the animal had a vicious tendency, or two, the owner was aware of that vicious tendency. You understand? Before we move any further, before we even go any further, look at what the time is. Oh my gosh, it's what? Pop quiz o'clock. And so it's important that the plaintiff, that person who has been injured, he has the onus. The onus is upon the plaintiff to prove scienter, to prove that the owner knowingly kept a dangerous animal in his custody. But then some people keep lions, and those lions are very sweet, gentle lions. In that case, is that lion a domestic animal, quote unquote, or it's a vicious animal? How exactly do we determine what is vicious and what is harmless? Like what's the standard of proof? How do we prove that? Now, one of the principles of the scienter action is that determine whether an animal is harmless or harmful, dangerous or not, is dependent on the judge, and he might come upon this realization, this knowledge, either through judicial notice or expert evidence. Judicial notice or what? Expert evidence. And let me explain that. So in the case of McQuaker versus Goddard, this is what happened. In this case, the plaintiff went to a zoological garden, like a zoo basically. He went to a zoo. And then while he was in the zoo, he was lawfully there. And then he fed the camel 3 apples. He fed the camel the first one, the second one, and when he got to the third one, the camel beats his hand. The camel beats his hand. The plaintiff brought an action, and they were trying to determine whether or not a camel, or the camel, that specific camel, was a domestic camel, was domesticated, or whether the camel was vicious in nature. The plaintiff brought 2 witnesses. Maybe this one is family members, I don't know. But the plaintiff brought 2 witnesses, and those 2 witnesses said categorically that that camel was one of unusual and unsure temper, and so that the camel, quote unquote, had no swings. That was what the plaintiff's witnesses said, right? However, the owner of the zoological garden brought experts in as it relates to camels, and he said that particular species of camels had they were usually very gentle, they were usually very calm, and so perhaps the plaintiff intentionally provoked the camel that led to the camel biting the arm. And so the court took judicial notice and expert evidence from those experts and held that a camel is not a wild animal, and the camel it was not usual for a camel to bite humans. And so the court held that based on this, the plaintiff could not bring an action because there was no strict liability, and that animal was not one that had natural propensity or natural inclination to be violent. So yeah, don't forget to like, comment, subscribe, and share, and I'll see you here in the next video. Can you nice day?